Okay, can people hear now? Okay. All right, so I'm going to start over. Sorry about that. How do I minimize this? Okay, sorry about the hiccup there. Hopefully everyone can hear now, and if there's any problems, go ahead and raise your hand or type something into the chat box. So my name's Nickole Miller, and I'm a legal fellow with the Public Law Center. For those of you who aren't familiar with the Public Law Center, we are a nonprofit organization based in Santa Ana, and we provide free legal services to people who live in Orange County and are low income. And we use a combination of staff attorneys and also pro bono volunteer attorneys to provide free legal services in the areas of family law, housing law, consumer law, and immigration law. And we're in the process of developing and creating a new program to help respond to the great need in Orange County for folks who are looking for information and legal representation for deferred action. And just to let you know, so the purpose of this presentation today is to give everyone a really good framework of what deferred action is. Nothing here should be taken as legal advice. It's really just to give you a good overview of deferred action. A lot of the information I'm going to be giving today is based on what the Department of Homeland Security has said up to today about deferred action. However, they're continually revising the program. It's very new, and so things are subject to change. And so just be aware of that. So what is deferred action? Deferred action is essentially an administrative act of grace. It's basically a recognition the U.S. government has the right under the law to initiate removal, or also known as the deportation proceedings, or not to do so. And on June 15, 2012, the Obama administration announced that certain young people who are brought to the U.S. as children, educated here, who've lived here for a period of 5 years or more, would be given a temporary reprieve from deportation and given a chance to work. The deferred action came about in large part due to the failure of Congress to pass the DREAM Act. So the DREAM Act is legislation that would provide a path to permanent residence status for young undocumented people who have grown up in the United States but have been unable to work, to join the military, or attain higher education because of their status and because of current immigration laws. The DREAM Act, as I said, has not been passed by Congress, and so in response, the Obama administration announced DACA, which is an immigration policy. It's really important to understand that unlike the proposed DREAM Act, DACA is not law. Only Congress is able to pass new laws. So what this means is that DACA is subject to change. It can change based on a new president being elected this upcoming November, and it can also be changed by the current administration if they so choose. So what are some of the benefits of deferred action, or DACA? The first is that recipients of deferred action are given permission to remain in the United States for 2 years. And as the policy is written right now, after 2 years, DACA recipients are able to apply for renewal. DACA also allows for people to get authorization to work. It's often, you might hear it referred to as a work permit. And with the work permit comes the ability to get a restricted Social Security number that allows people to work as well. In California, there is a current proposal that's on the desk of the governor right now that would allow DACA recipients to receive California driver's licenses. So as of right now, in California, it's sort of unclear whether or not DACA recipients will be able to receive a California driver's license. Another thing that DACA recipients will be able to do is they'll be able to travel outside of the U.S. However, it will be a travel outside of the U.S. is will be only available to people who have petitioned and are granted advanced parole. And advanced parole is permission, essentially, to leave the U.S. for humanitarian, education, or employment purposes. However, it's important for people to understand that they really need to consult with an attorney because there are some consequences that can cause problems for people who decide to leave the United States. As I mentioned before, DACA is not law. DACA does not provide legal status, and it doesn't provide a pathway to permanent residence or U.S. citizenship. It doesn't give applicants the opportunity to petition for status for their relatives. And DACA is discretionary, and it can be withdrawn at any moment. So, for example, someone who receives deferred action and commits a crime, their DACA status could be withdrawn. Okay, so there's a lot of sort of elements that for someone who wants to apply for DACA that they have to prove. Today I'm not going to be talking about this sort of documentation that applicants can provide to prove each element. I'm just going to be going over the general elements and sort of unpack them a little bit. So on your screen you'll see a list of all the elements that need to be met, and I'm going to go ahead and go and explain each one. So the first big requirement is the age requirement. In order to qualify for DACA, the applicants must have been under the age of 31 years old as of June 15, 2012. Unfortunately, if they were 32 years old, 33 years old, they will not qualify. This is a very hard rule. Also, applicants must have come to the United States before turning 16 years old. So again, this is a hard, fast rule. Anyone who came to the U.S. when they were 17 years old, 18 years old, they will not be eligible for deferred action. At the time of applying for DACA, the applicants need to be at least 15 years old. There is an exception if the applicant has a final removal order, a departure order, or is it currently in removal proceedings. They can go ahead and apply for DACA even if they're under 15. Am I talking too fast, or am I doing okay? Anybody have any questions? Everyone seems to be okay? All right, I'm going to continue on. Please don't hesitate to interrupt me. Okay, the next requirement is the presence and residency requirement. So applicants have to be physically present in the United States on June 15, 2012. So if the applicant was not in the U.S. on June 15th, they are ineligible for DACA. The other requirement is that they have to have continuously resided in the United States since June 15, 2007. So continuous residency means that there was means that since June 15, 2007, they haven't had any prolonged departures from the U.S. So DHS has clarified that brief, casual, and innocent absences from the United States before August 2012 shouldn't cause any problems with continuous residency requirements. Applicants who have left and re-entered the U.S. since June 15, 2007 should consult with an attorney or a BIA accredited representative before applying for deferred action, just to make sure that their absences would not be deemed to be prolonged. Additionally, if the absence was due to a deportation order, the applicant will not qualify for deferred action. It's really important that applicants understand that any travel outside of the United States after August 15, 2012, when the application became available, would disqualify them from receiving deferred action. So if anyone comes to you wanting to know if they can travel outside the U.S., the answer is no. It doesn't matter if there's a really great reason. This is a hard and fast rule. A lot of people have had sort of questions about, well, does it matter how I came to the U.S.? And the answer is, for DACA purposes, no. So if someone came in with the help of a smuggler, if someone came in using false documents, if someone was waved in at the border and not inspected, that should not affect someone's eligibility for applying for DACA. However, it's very important that if anybody came in to the U.S. Using false documents, making false claims.
What does BIA stand for?
Oh, BIA is the Board of someone asked what BIA stands for. BIA stands for the Board of Immigration Appeals. And so if you can be approved, if you're not an attorney, to work on immigration-related cases. And so we suggest that only applicants consult with an attorney or a accredited representative before applying. There's been a lot of issues with fraud, immigration fraud, notorious, who are not actually accredited or who do not have a law degree. And so we want to make sure that people only go to attorneys or BIA accredited reps if they have questions. Okay, so like I was saying, it's very important to note that although how someone came into the United States doesn't necessarily affect someone's eligibility for deferred action, there's still a lot of unknowns of sort of what the next steps will be for DACA and what the next steps will be in terms of finding some sort of more permanent pathway to legal status here in the U.S. So anyone who has any concerns about fraud or false claims to U.S. citizenship should really talk to an attorney before they apply to make sure that they're not setting themselves up for any problems in the future. Another requirement is that the applicants must have had no lawful status on June 15, 2012. So for example, if someone came into the U.S. on a tourist visa or a student visa and they overstayed, that's fine. What the requirement is just they have no lawful status. So that visa must have expired as of June 15, 2012. Additionally, the applicants must have no lawful status when requesting deferred action. So someone who is applying, say, for a U visa or VAWA or some other form of immigration relief, they can go ahead and also apply for deferred action, but they must have not received lawful status when they submit their application. The next requirement is the education or military requirement. In order to be eligible for deferred action, the application must have either a high school degree or a GED certificate. They must have been honorably discharged from the U.S. Armed Forces or Coast Guard, or they must be currently in school. And currently in school can mean is a pretty broad category. So the applicant could be enrolled in public or private K through 12. They could be enrolled in some sort of literacy or career training program that has the goal of placing them either into some sort of other college program or employment program. Or they could be in some sort of educational program that's helping them obtain their GED or high school diploma or high school certification equivalent. The next issue is criminal bars. So there's sort of two different sets of categories when looking at criminal issues. There's one section are things that automatically disqualify you from applying for a deferred action, and the other is a step that is sort of more discretionary, and having some sort of criminal history may or may not cause problems for your application. So first we'll look at the automatic criminal bars. So barring very, very exceptional circumstances, which unfortunately the Department of Homeland Security has not given any real examples of what those exceptional circumstances would be, applicants with the following criminal offenses are automatically ineligible for deferred action. The first is 1 or more felony convictions. The second is 3 or more misdemeanor convictions. And the third is 1 or more significant misdemeanor convictions. So felony conviction is defined as any federal, state, or local offense that's punishable by imprisonment of more than 1 year. And it doesn't matter how much time the person actually is served or what sentence is imposed. It just matters that there's a possibility of imprisonment for more than 1 year. The next is 3 or more misdemeanor convictions. It's important to note that those 3 or more misdemeanor convictions should not arise from the same date and from the same act, omission, or scheme. So for example, if someone commits battery and assault and also robbery all at the same time in the same act, that will not count for the 3 or more misdemeanor convictions. However, those are likely not misdemeanor convictions, so that's probably a horrible example to give. So a misdemeanor is any federal, state, or local offense that's punishable by imprisonment of 6 days to 1 year. And again, this is regardless of the actual sentence imposed. The next automatic criminal bar are significant misdemeanor convictions. And this is a new concept that was created specifically for deferred action. So a significant misdemeanor is a misdemeanor. So again, using the definition before, that's where there could be imprisonment of 6 days to 1 year. And then there's sort of 2 separate categories. One is regardless of the sentence imposed. So it doesn't matter how long they're supposed to serve. If it's an offense of domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, or driving under the influence, you're automatically disqualified. And unfortunately, a lot of people are coming with DUIs, and that is unfortunately an automatic bar from deferred action. The second is if it's not a crime listed that I just listed, if the applicant was sentenced to time in custody of more than 90 days, that will count as a significant misdemeanor. It's important that if anybody has any sort of criminal record or concerns, that they really speak to an attorney before they go ahead and apply for a deferred action. The Department of Homeland Security has stated that they will refer cases of applicants who have significant criminal records to Immigration and Customs Enforcement for removal or deportation. So anyone who has any sort of criminal record or concern really should speak to an attorney because they do not want to set themselves up for deportation. That section might have been a little confusing, so if anyone has questions, please go ahead and let me know, okay?
Right.
Any questions?
If you guys have a question, raise your hand and I'll unmute you so you can ask. A little delay.
Okay. Okay, seems like no one has questions, which is either because I'm doing a fabulous job or people are totally confused and don't even know where to begin. So we'll have a chance at the end for more people to ask questions as well. Okay, so like I mentioned, even though someone maybe doesn't have a conviction and isn't automatically barred from deferred action, there are some other criminal offenses and concerns that we want to make sure people are aware of. So state or local immigration offenses, juvenile delinquency adjudications, expunged convictions, minor traffic offenses, and arrests, those are things that do not automatically disqualify someone from receiving deferred action. However, DACA is discretionary, so that means the Department of Homeland Security does not have to give anyone, even if they qualify on the surface, deferred action. So what they're going to be doing is looking at the entirety of someone's criminal history and sort of weighing the totality of the circumstances. So again, anyone with any type of criminal record, even if it's just an arrest record, to really consult with an attorney before applying for deferred action. The other concern is public safety and national security. Deferred action will only be granted to applicants who pose no threat to public safety or national security. And again, this is sort of like a vague catch-all category. Oh, I think someone has a question.
The question is, what if they were convicted and later it was overturned?
Okay, so again, with the someone asked what if someone was convicted and it was later overturned. Again, that's something they'll want to consult with an attorney about. It really will depend on what sort of type of conviction it was, whether it was a felony or a misdemeanor or a significant misdemeanor. And it might not be an automatic bar, but again, it's something that could potentially disqualify someone because of the fact they're looking at the totality of the circumstances. So unfortunately, I can't give you an exact answer to say whether or not someone can go ahead or not go ahead if they have a conviction that was later overturned. If that's a real concern for someone, they really should consult with an attorney and make sure to bring all their criminal records with them. Okay. All right, so going back to the public safety and national security concerns, some of the things that the Department of Homeland Security has said they're going to be looking at to see whether or not an applicant poses a threat are past, present, or suspected gang membership, participation in criminal activities, and participation in activities that threaten the United States. I think the issue that's going to come up the most is the gang membership, and in particular suspected gang membership. So something to think about is applicants are required to submit photos when they apply. And so people will want to be particularly careful of what kind of tattoos they have in their photos. If they've ever been stopped by the police and questioned about gang membership, those are things that they will want to consult with an attorney about before they decide whether or not they want to go ahead and apply for deferred action. And again, as I mentioned previously, no convictions required. So any contact that you've had whatsoever an applicant has had with law enforcement can be a means for them to decide to deny someone deferred action. Okay, so some of the risks of applying for deferred action. A lot of people are sort of wondering, well, here I am, I've been sort of in the shadows, and now I'm coming forth and I'm giving the government all this information. And wondering sort of what's going to happen with that information. Well, the Department of Homeland Security has stated that they're not going to be referring cases to the U.S. Immigration and Customs Enforcement or Border Patrol unless the applicant's case involves a criminal offense, it involves fraud, or it involves a threat to national security or public safety. They've also stated they don't intend to use any of the information submitted to pursue removal of family members or of either approved or denied applicants. So again, just sort of a caution, anyone who has concerns of criminal activities, gang affiliations, who has maybe juvenile offenses, who has sort of concerns about possible false claims to U.S. citizenship, who've used unauthorized Social Security numbers, or who have come to the U.S. unlawfully in the past after an order of deportation, should really consult with an experienced immigration attorney before deciding to apply for deferred action. A lot of these things don't in and of themselves disqualify them for deferred action. However, it could set them up for a lot of problems in the future. And that's something they really need to speak with someone about to get sort of a case-by-case assessment of the risk of applying. There's a couple of great resources that I want to share with you guys. So I'm going to go ahead and open them up on the computer. Hopefully you're able to view them. Okay, so the first one is the U.S. Citizen and Immigration Service website. It's updated actually fairly frequently. On this website, as you can see over here on the related links, there's a section that has frequently asked questions. The application itself is found over here under forms. And there's also a blog where they post any sort of updates about filing processes or questions that have been coming up. It's also a nice place. They have a video that's, basic but informative, and gives you, again, a list of all the different guidelines and sort of unpacks all the different requirements. Another website we've been referring people to is We Own the Dream. It's a great resource for people who are trying to figure out whether or not they're eligible for deferred action. They have an interactive tool that you can use here and plug in some of your information to get sort of a basic assessment of whether or not you qualify. It's also wonderful. It has upcoming events. So throughout the country, there's different types of clinics, workshops, educational programs being held on deferred action. So people can go here to check out and see if there's anything in their area. Here they have a section on recent news, so things that have been reported about related to deferred action. And also people can sign up to receive alerts on deferred action as well. Okay. Oops. How do I go to the slideshow? Okay. Okay, well that's sort of the end of my presentation today. I know that was a lot of information in a very, very short period of time. So I want to open it up now to questions to see if anyone has any questions or concerns, or if anything wasn't clear and I can help to help clarify anything.
If you have a question or a comment or a suggestion or anything, go ahead and raise your hand and I will unmute you. Jessica has a question of, is there a maximum number of applications being accepted?
Nope, there's no, as of right now, there's no maximum number of applications. We're encouraging people who think they qualify to go ahead and to apply. A lot of people are wondering whether or not do I really need to go see an attorney, and there is no easy answer to that. If people don't have any criminal records concerns, if people don't have any concerns about using false Social Security numbers, if people do not have any concerns about how they entered the U.S., it might be something that they can go ahead and fill out on their own. However, it's always good to sort of consult with an attorney to make sure that you're not setting yourself up to have any problems in the future with your immigration status.
Thanks. And then, Elena, I'm going to go ahead and unmute you here so you can ask.
Okay, so if you want to introduce yourself and state your question.
Yeah, my name is Elena Lopez with Children's Bureau. And my question is, there's a way to have this presentation emailed to us so I can share it with my coworkers?
Yes, we will be sending out a PDF of the PowerPoint to everyone. Additionally, we'll be sending out a list of organizations in Los Angeles County who are providing free or low-cost legal services. As I mentioned at the beginning of the presentation, the Public Law Center is still in the process of creating a deferred action program. So we do not yet know exactly what our services are going to be. And as soon as that is something we figure out, I will also send out an email that updates everyone on what kind of help Public Law Center can give to your clients as well.
Linda, did that answer your question?
I'm sorry. What about the San Diego County?
I don't. If you send me an email, my email is included in the PDF that will go out to everyone and should be on your screen right now. I can send you a list of organizations in San Diego County. That's not included, though, in the list that I've already that will be going out to you after this presentation.
Well, thank you so much.
Okay, thank you.
And then we have another question. Are there any costs involved once the application starts the process?
Yes, so there is. I'm going to go back and onto this.
And a follow-up with that is, are there any other fees for applying?
Okay. Okay, so I'm back onto the USCIS website, and you'll notice on the right there is forms there's going to be two forms that people need to fill out. One is the I-821D, which is the deferred action application itself. The second is the I-765, which is the application for employment authorization. That is, that's what's going to end up costing people money. It's roughly $480. I'm trying to look at the exact number. Here we go. So the total fee is $465. That includes $380 worth of a processing fee plus the $85 for our biometric services. So when people apply after they've sent in their application, they'll receive a notice letting them know they need to set up a biometrics appointment. Basically, that means that people are going to be getting criminal background checks. So the total fee is $465. There is unfortunately no fee waivers available. There are fee exemptions in very, very limited circumstances. And if people have questions about that fee waivers, it's right, or the fee exemptions, excuse me. It's right here. I'm kind of circling the application, and the guidance is on the right-hand side.
Another question, will Public Law Center be offering legal clinics to review applications?
So that's something that we're in the process of working out at the moment. We are working closely with the Orange County Dream Team, and the Orange County Dream Team is providing general education workshops and legal clinics throughout Orange County, usually about once or twice a month. I can give you, email out actually to everyone a link to their website so that people can tune in to when they're hosting workshops and legal clinics. So we are working with them, and then we are in the process of creating a legal clinic as well that will most likely just be helping people in central Santa Ana, but again has not been finalized.
And another, how long is the process from time of filing until the time they get approved or not?
Well, it's actually pretty amazing. So the application just went live on October 15th, 2012. And as of yesterday, they have, this week actually, they've started sending out the first round of approvals. So within a month, which is extremely fast, and I'm not sure that that's sustainable or not. It could be, again, anywhere from a month to a few months, depending on how things go in the future.
And then we have Maria. Maria, I'll go ahead and unmute you here so you can ask your question. Maria?
Okay, go ahead and introduce yourself and say your question.
Well, Maria, I will go ahead and mute you back. Maria asks, what about the employment permit application? How much is the fee for that?
So the $465 fee that I had mentioned before, that covers both the deferred action general application and the employment authorization application. Both need to be submitted together.
Another question, is there a penalty for a person assisting in the filing of the application if the beneficiary lies with their information, but you do not know they are lying? If they lie in their application but you're not aware of that, are there any penalties?
You know, I'm not sure the answer to that question. I can get back to people. If you want to shoot me an email, I'll put my email up again, and I can look into that for you.
Another, Maribel wanted to just clarify, potential candidates for DACA need to be enrolled in school when they apply. Is that correct? Or are other career-oriented trainings appropriate? Sometimes clients come in having been out of school for a few years and wonder if they can apply.
So there's 3 ways you can meet the education and military service requirement. So one is you could already have graduated from high school or received your GED. And the other is that you could be currently enrolled in school, which could be a career training or some sort of vocational training program as well. And that's just, you need to be enrolled at the time you apply. So it doesn't matter if someone was in school and you know, stopped going to school for some time and has just recently re-enrolled, that should be fine.
All right. What was the reasoning behind this action plan, since it's not a path for citizenship?
So as I mentioned before, the DREAM Act was not passed by Congress. Congress is the one who needs to pass, is the only one who can make a law. And I think the Obama administration wanted to have some sort of response. And so one way, since Congress was not able to pass the DREAM Act, they used deferred action as a way to give some sort of benefit to people who came over to the United States at a very young age at no fault of their own and are in school or have been in the military and would like a chance to work and to have some sort of protection or status here in the United States.
Another question, if the applicant is under 18 and qualifies for the program, do they need their parent consent for anything? And if so, what if they are also undocumented and don't qualify for DACA because they're over the age of 31?
So unfortunately, deferred action is only for people who were under the age of 31 as of June 15, 2012. There is no way to get around that requirement. In terms of whether or not someone who's under the age of 18 needs their parent approval or parent signature, the answer to that is generally no. In order to apply for deferred action, unless you're in removal proceedings currently, you have to be 15 years old. And 15 years old is the minimum, is an appropriate age for someone to sign immigration forms. So if you're 15 or older, you do not need someone else to sign the forms along with you.
And then do you have any other information on organizations in Orange County?
Unfortunately, really, there's not that many organizations in Orange County who are providing DACA services other than the Orange County Dream Team. So we've been referring people to the Los Angeles organizations who are providing free and low-cost legal services. I know that the Mexican consulate is referring people, has a list of private bar attorneys who are providing deferred action services, and so that might be another resource for Mexican nationals.
Any other questions?
Any other questions?
Can you become, after the 2 years, hey, Rocio, I'm going to go ahead and unmute you here. You can ask your question for Nickole.
Hi, Rocio. Do you want to state your question?
Rocio, I don't quite understand. I think she's asking, can you become, after the 2 years, an American citizen?
No, as I mentioned, deferred action is not a path to citizenship. After the 2 years are up, you can reapply so that you can continue to have work authorization, but deferred action does not provide any path to citizenship. Any other questions?
I know certain documents need to be translated. Is there a website where these forms are made available for clients to view it on their own?
One thing that I can provide, we're in the process of finalizing what we're calling a document checklist that will include a list of documents that can be submitted to prove each of the eligibility requirements for deferred action. There's also a similar document checklist that's on the on this website. Hold on, let me just pull this up here. On the Own the Dream website, they do have a document checklist as well. So things like birth certificates, they do need to be translated from the original language to English, and they need to have a certification attached to them. And I can email around a sample certification as well, but I believe the We Own the Dream website also has samples for people to use.
And then, Alina, I'm going to unmute you again. You have another question?
Thank you. I just have a quick question. For how long this law or how you call it, DACA will be, there is a time limit to apply for these, so we can tell people to hurry, or what's the deal?
Okay, so there is no time limit to apply, but as I mentioned at the beginning, this is a discretionary policy. It's not a law, and so since it is a policy, it can change at any time. So it could change if there's a if Romney is elected president. We don't know what he would do with deferred action, and even President Obama could change deferred action at any time.
Okay,
so while there's no deadline to apply, it is something that's subject to change at any moment.
Okay, thank you.
Mm-hmm.
And I've been trying to write the answers to these questions as they come in, and so we will forward, along with the presentation materials, a collection of all of the questions that were asked. We are also recording this webinar, and we'll make it available on our website and by email. So if you would like to rewatch it to further clarify any of the points, and again, Nickole has listed her email here, so feel free to email her. The presentation materials that are available on Google Docs will also be emailed, so if you didn't get a chance to download those there, we'll have that for you. But for the questions that weren't answered, in the answer portion of that list of questions will be answered by audio, and so I apologize, but there's only a few of us here, and so you would be able to hear the answers to that question through the audio. But if anybody has any other questions, you can raise your hand if you'd like to ask it over the phone, or you can write it out. Okay, Maribel, I'll go ahead and unmute you. Actually, Maribel, will you be so kind to write it in the question dialog box, because it appears as though I can't unmute. Another question here: what happens if you're approved but we get a new president in November? So I think Victoria, Nickole answered that with the, we don't quite know what will happen after the presidential election, but that this is sort of what's going on at the moment.
Exactly. And all the application materials and all the materials issued by the Department of Homeland Security, they have a note saying that deferred action is subject to changes at any moment. So unfortunately, I can't give you an answer to that.
And then Marcel is just saying thank you for the great webinar. Claudia, I'm going to unmute you here if you'd like to ask your question over the phone.
Hi, Claudia. Do you want to state your question?
Claudia? Well, while we're waiting for Claudia here, Maribel says, I have clients that might not have access to their documents, for example, birth certificates. What recommendations would you recommend that they do to secure them?
Okay, so there's usually different ways to get around each of the requirements. So say, for example, someone might not have a birth certificate, but they need to prove their age. Perhaps they have a passport or some other sort of government-issued form of identification. The other option is to go to their consulate. Each country, unfortunately, is different, so I can't tell you that there's one path to follow. But they can contact them and ask about how they can go about getting a certified birth certificate or a passport of some sort as well. It's very important to have documentation for each of the elements each of the deferred action requirements. And like I mentioned, I will go ahead as we finalize our document checklist, send it out to people so that they can hand it to clients who have questions about what kind of documents to submit. I hope does that answer your question, or?
Maribel says yes.
Okay.
Any other questions here?
Any other questions? Do people have questions about sort of what documents need to be submitted that you would like me to answer or address right now, or are you fine, or would you like to just wait until I send out the document checklist?
If you would like Nickole to kind of clarify a little bit more during this session, go ahead and raise your hand.
Okay. Just one second. Let me grab my list at the just.
Are there any other questions in the meantime? So another question whenever you're ready.
Sure.
Great. Keep on sending the questions in through the question dialog. That way we'll be able to have a log of all of the questions that were asked. So one question, would you recommend we tell applicants to remove tattoos?
We don't want to recommend that anyone necessarily cover up or try and hide anything on their applications. However, it really would depend on the type of tattoo. If it's a gang-related tattoo, then they don't want to have those sorts of images necessarily submitted in their photographs. So it's kind of on a case-by-case basis. However, we're not recommending anyone submit applications that misrepresent anything.
And another one, is it one application per person?
Yes, so it's one application per person. So you send in the sort of the general deferred action application along with the work authorization application together in one packet.
So 2 questions here. If this is not a path towards citizenship, does it make it easier for the applicant to apply for citizenship while they are under DACA program?
The deferred action or DACA program has no correlation with any other sort of form of immigration relief. So receiving deferred action will not necessarily make it easier for someone to receive to start on a path of for citizenship with some other form of immigration relief. However, we don't know what the next steps will be for deferred action. Hopefully in the future there's some sort of more permanent solution and path for citizenship for folks who are undocumented and who have received deferred action. We just don't know at the moment.
Another one would be, do you know if they need to attend an interview in order to get their work permit, or will everything be done through the mail?
Things will be done through the mail. And there'll be a follow-up request in terms of submitting fingerprints for background checks and things like that.
And then another, one of our attendees assisted a client with filling out a form, and the status at time of entry was very challenging. Even after reading the instructions, it was still very difficult. Is there a cheat sheet available?
There is no sort of cheat sheet necessarily available for how, at least that I have access to at the moment. It really is something that's very case specific. So without knowing the specifics of how someone entered, I can't tell you how they should answer that question. Sort of the catch-all response is no lawful status. However, I do not know if that applies to your particular client or if that will apply to everyone who you may come across with in the future. Okay, I have in front of me the list of the evidence list, so maybe I'll take one more question and then I'll go ahead and move to the document checklist in terms of documents that can be used for each requirement. Okay, so there's 3 questions, so I'll go ahead and answer them really quick that have popped up on the screen. One is from Maria. She's wanting to know if applicant DACA recipients will be allowed in the future to apply for legal residency. Again, as I mentioned, deferred action isn't any path to legal status. However, things can change in the future, and perhaps this could be the first step. But as the policy is written now, it has no effect whatsoever on legal residency. The next question is, if a person is granted deferred action, but the policy is changed or removed, does that mean their status will be changed? Again, and this is coming from Wendy, again, unfortunately I don't have an answer for you because it will really depend on what the changes are moving forward. So there's quite a lot of unknowns. This was announced, as I mentioned, June 15th of this year, and the application became live on August 15th, so it's been about a month, and there's been continual updates, and so the best is just to pay attention to that USCIS website, which I included in the PowerPoint, for any updates or additions or changes to the deferred action policy. And then the last question, what are the benefits for a 15-year-old to apply for deferred action since it's only good for 2 years and the child will still be in high school? Well, one of the benefits is, although it doesn't give legal status, it does give someone some sort of protection from deportation. So that would be one of the benefits. Another benefit would be, since we don't know what the next step will be, the hope is that if someone applies and receives deferred action, it can set them up for some sort of immigration benefit in the future, although it's unknown. Okay. So going over quickly the evidence that's going to be needed to apply for deferred action. The first is that applicants are going to need to prove their identity and their age. So, for example, they're going to need to prove that they were under the age of 31 on June 15, 2012. And they'll need to also prove that they were under the age of 16 when they first came to the United States. Some of the documents that people can use to prove this are a copy of a birth certificate, a copy of a passport, either a valid or an expired passport, school IDs, any other sort of documents issued by their government or by the Department of Homeland Security. Some things to show that the applicant arrived in the United States before the age of 16 and that they've continuously resided in the United States since that time are school records, so things like transcripts would be very helpful, diplomas, medical records are usually good, particularly vaccine records. Financial records, so someone might have bank statements or checks or pay stubs, credit card bills, rent receipts. Employment records could be an example, though people will want to be careful if they've used a fake or false social security number. Any sort of phone record, enrollment in some sort of sports or extracurricular activities could be good records. Things to prove that you were in school or you graduated are diplomas, GED certificates, report cards, transcripts. Those are the main kind of documentation you're going to need. If anyone has any criminal records, they will also want to get those as well. However, I have to remind people that if anyone has any sort of criminal history, they really want to consult with an attorney before they submit any materials or apply to deferred action. That's all I have at the moment, unless if there's any final questions. Otherwise, I will go ahead and end. Okay, so someone had a question of whether or not the Public Law Center can train people on filling out deferred action applications. That's actually something I can bring back to my supervisors at the Public Law Center if it seems like there's a need. I think, can we do the poll?
Yeah.
I'm going to go ahead. We're going to open up a poll, and if people would like to respond and say whether or not they're interested in being trained on sort of the nuts and bolts of filling out the application, please go ahead and respond yes or no. That way I'll have a better sense when I go back to my supervisor of how many people are interested. Okay, so the poll should be open. People want to go ahead and respond. You want to tell me the other question and I'll respond while they're in and out.
And then the other question was for high school age children that qualify, will this help them apply for college easier since they're acquiring a temporary Social Security number?
So the Social Security number is only for work purposes. It's not for things like financial aid. So in and of itself, it won't necessarily help people in applying for college. It will just give the work authorization.
And then our poll is 74%.
Okay. Okay, great. Any final questions?
I don't see any other.
Okay.
Maricela, I will unmute you. I see your hand is raised. Do you have a question? Jessica, I see that your hand is raised. Do you have a question? All right. Well, I think that's...
Okay, well, I'm going to go ahead and end the webinar. As we mentioned before, we'll be... Oh, we do have one final question.
For those who are granted the deferred action, will they be eligible at that point to apply for health insurance coverage such as Medi-Cal?
The deferred action is just for work purposes. It's not in and of itself necessarily going to be helpful for health insurance or other public benefits. However, there is legislation currently in California that may give that sort of benefit. Sorry, a lot of these answers are vague or unclear. It's just a lot of this is very unknown and new, and so I can't give definite responses.
All right. Well, your email's here, so if you guys have any additional questions that Nickole couldn't get to or we didn't answer all the way, you have a question that comes up later as you're looking through the documents, feel free to email her. And if you'd rather, you can also email me, and I will be sending out the material, so you'll have my email that way. And then I will forward on the question to Nickole.
Okay, thank you. Have a good afternoon.